So in the past year, there's clearly been a greater recognition in the personal injury trial bar of the need for using technology and AI. So again, it's been, I will say, it's been unbelievably transformative in the way we practice, and I could go into more detail.
Hi, and welcome to Main Street AI, the podcast where traditional businesses are quietly revolutionizing their operations with artificial intelligence and winning. In this podcast, I sit down with industry leaders from law firms and professional services and other Main Street businesses to explore their AI journey. We dive into the opportunities they see, the challenges they're navigating, and the real impact of AI on their industries. Whether you're AI curious or ready to implement, this show brings you insights from leaders who are actually using this technology to serve customers better, empower employees, and drive profitable growth. Charles Price has been practicing medical malpractice law for 43 years. He's part of a 12-attorney firm in Bridgeport, Connecticut, where he and his son Will handle the most complex and emotionally demanding cases in the personal injury world: birth injuries, brain damage, preventable deaths. He's also, quietly, one of the most AI-forward practitioners the show has featured. In this episode, Charles talks about all of it, and about why the cases that bring in the least financial satisfaction are sometimes the ones that matter the most. Let's dive in. Hi, welcome back to the Main Street AI podcast. This is Stephen Whittier with Satori Coach IO, and today I'm joined by Charles Price of Miller, Rosnick, D'Amico, August, and Butler. That was a mouthful. Thanks so much for joining today, and please go ahead and tell us what you do from high level.
Yeah, good morning, Stephen, and thanks a lot for having me. It's a pleasure to be with you.
My
So
pleasure.
I am a medical malpractice trial attorney primarily. That's been the concentration I've had for the past 43 years or so. Um, I do a wide range of other types of personal injury work as well: trucking accidents, motor vehicle accidents, dog bites, premises liability. But my concentration is and has been in the medical field for all these years. I practice with a firm of 12 attorneys. My son, Will Price, is an attorney at the firm, and he and I are the ones who primarily handle all of the medical malpractice litigation that we do. I'm a member of the Connecticut Trial Lawyers Association and have been on the board of directors for that for some time now. And um, yeah, we have a very busy practice in Bridgeport, Connecticut. We have one of the larger numbers of cases on the docket in the state of Connecticut, and we're a very active firm in Bridgeport.
Great. Um, what would you say? I think this is always a great question to ask, really in any legal domain. But I think it's maybe one of the more sensitive things when you're talking with something like a personal injury, which can be in a very acute type of situation. What, as a professional, would you say to people who aren't legal professionals that maybe they underestimate about what you do, and maybe the timing, things that you wish that they would know before they actually enlist your services?
Sure. So clients underestimate the degree of investigation that has to go into a case, and they just presume that if they were in an accident, it's going to be somewhat cut and dry. But of course, many times the facts of personal injury incidents are not cut and dry, whether it's a premises liability case and a person is exiting a doorway and they fall because of what they believe is a defective condition. They think it's clear in their mind that there was a defective condition and therefore they must automatically be entitled to something. But that is, of course, not the case. There are issues relating to comparative responsibility, which is a legal doctrine that there is, at least in Connecticut and most states, which puts some degree of responsibility on the person who was hurt. That's an element that they often don't understand. There's the element of notice, which the landowner or property owner has to be aware of the defect, either actually or constructively. So those are some things that clients in, for example, the premises venue do not understand. In the medical malpractice venue, they have a loved one who died in the hospital. They believe it was a result of some substandard care. They don't really understand that there are a number of different elements that go into a malpractice case. It's not just whether there was negligence in some fashion, but was that negligence in fact a substantial factor in bringing about the harm or the death? So that's another thing that people don't understand what the legal elements are to a claim. And of course, that's what we go to law school to study. The last thing I'll say about medical malpractice cases in particular is that they require extensive amounts of medical research, consultation with experts, and ultimately getting an opinion from an expert in that field or specialty that's at issue that there was negligence.
I can imagine too, one of the things we hear in certain fields of law, whether it's like, as you mentioned, medical malpractice, a loved one passing away, divorce law, where, people are going through very difficult challenges, especially when it has to do with child custody. So this is one of those fields where you might be talking to somebody in the worst day of their lives. I can imagine that
Sure.
that a massive part of what you do is dealing with the emotions and trying to navigate that as well as all of the particulars of the legal matters.
Very perceptive point, and it's very accurate. We are often seeing people shortly after something terrible has happened, and so there's a tremendous emotional overlay, and piercing that and getting people to understand that this is a process. We don't jump to conclusions. The process has to be followed is very, very difficult because these people are dealing very often with the loss of a loved one or a very serious complication that's happened.
Mm.
And it is one of the more difficult parts of the job, really, from the beginning, from the first meeting, and then throughout the pendency of the litigation while the people are waiting for some result or some progress to be made on the case. They're living with the uncertainty of the outcome. And then even at the end, Stephen, when you've successfully resolved the case, it's a mixed feeling because you're compensating a person for an injury or a loss that doesn't change the injury or loss. So that is very difficult, and it's been one of the more difficult things in my practice. For example, in a case where a child has died and you're bringing a claim on behalf of the family, there's no amount of money that can ever fully compensate the family for that loss. And so it is a very mixed feeling about even successfully litigating these cases.
Absolutely. Takes a particular constitution to be able to do that.
Sure.
With uh, where I wanted to go next is kind of pivot over to the tech question. How do you see, maybe particularly in your neck of the woods with malpractice, personal injury law, what are you seeing for trends in AI? How are you thinking about it? How are you engaging with it?
So it's probably, and while me, and my son Will, think that we're somewhat ahead of the game in terms of the legal profession. For example, in Connecticut, I would say in the last year, there have been at least 3 tech or AI related seminars put on by the Connecticut Trial Lawyers Association, and that those never happened before. Just recently, there was technology in the courtroom presentation by a bunch of lawyers who used a very high tech courtroom in Hartford, Connecticut, that my son and I have also used, where they have multiple projectors and screens, and it really is very conducive to a jury seeing the entire picture of a case. Um, so in the past year, there's clearly been a greater recognition in the personal injury trial bar of the need for using technology and AI. My son Will, who I will give all the credit to, really started way back with Chat GPT, and that was a bunch of years ago. And then in our practice, about a year and a half ago, we started exploring a number of different AI platforms. And what we did was we, of course, played around with ChatGPT, but then a number of other platforms came into being, or we became aware of them. For example, Perplexity is a platform that has its attributes and is excellent, for example, for current codes, research, and those types of functions. I've used it to get Coast Guard research on wave heights produced by boats traveling at certain speeds, because we have a case involving a person who was injured on a boat due to an excessive wake due to a boat traveling at high speed. So Perplexity is really good for that. What we did was we explored Gemini, ChatGPT, Perplexity, uh, a number of other platforms, and ultimately we also got exposed to a program, a platform, Claude by Anthropic, and it's been in the news very heavily because of the dispute it got into with the Pentagon about whether the Pentagon should be allowed to use certain functions of Anthropic's software for example, domestic surveillance. But anyway, we explored all these different platforms and we found that they had strengths and weaknesses. And then what we did was we asked each platform to cross compare itself to the other platforms. And what we did was we tried to synthesize all of that research so that we really got a very comprehensive understanding of what the strengths and weaknesses were of the different platforms. And one of the things that one platform that we settled on for a lot of our analytical research turned out to be Claude by Anthropic, and we've been using that very extensively in the past year and a half. But and not to go too far down the road, but some of these platforms, as I'm sure you know, Stephen, are what they call closed systems, and some are open systems, where the data that you may put into a platform is not per se confidential. And we, of course, deal with the HIPAA laws all the time and maintaining the confidentiality of patient records. So what we've learned is that there are platforms out there that are specifically geared to personal injury and medical malpractice attorneys that are closed systems that can protect the confidentiality of the patient records. We do use Claude for the co-work part of Claude for that type of analysis too, but it does require us to redact the names and other identifiers of a patient before we can upload their records to a open system. So again, I will say it's been unbelievably transformative in the way we practice, and I could go into more detail.
So would you say, based on everything you were just telling me, that most of your use right now has been with the tools around the research component, or are there other applications you're using aside from research?
Um, Far more than just research. So, for example, Perplexity. Let me back up. So, some of these platforms are clearly not good for certain types of research, and you've probably heard about attorneys being sanctioned for
Yes.
citing cases that do not exist.
Yeah.
And
No
so,
due diligence there. Yeah.
exactly. And you know, when I have a lot of friends and colleagues who for some reason do call me for advice about AI and the various programs and so on. And of course I emphasize to them the two main drawbacks, which is one, some programs, some platforms can be unbelievably sycophantic and tell you just what you want to hear based on the query that you gave it. Um, and the other thing is that the case citations or statutory citations are often wrong, just wrong. So you cannot trust it for those types of things. You must do your own due diligence. Um, but we don't use it just for research. We use, for example, Westlaw has a product co-counsel, which is very reliable and very solid for legal research, but it can't do a lot of other things that we need it and like it to do. So we will use Claude, for example, to draft complaints, draft legal documents. Um, we have cases, for example, involving um, we have a case right now against the state of Connecticut involving a lady who fell out of a transport van, landed on her head and neck in her wheelchair, broke her neck, fractured her skull, and died. And the state ended up doing a very long investigative report with interviews with dozens of witnesses and hundreds of documents. And we were basically able to upload that into our system, into Claude, and ask it to provide me a witness list. Every witness identified in this investigative report. Give me a list of all the documents cited in this report. Summarize this report for me. So those types of analytical functions we use these programs for all the time. We often need to draft what are called mediation statements, where you include pictures of an injury and the narrative of what happened to a person, and we will use the programs to help draft those. Of course, all of this work needs to be cross-checked by the attorney for
Yes.
accuracy and everything else.
That's excellent. Um, what would you say that, based on everything you're doing so far and everything you've seen, that you're most excited about for where everything is going?
So I'm excited about the fact that it allows us to work smarter and not harder.
Mhm.
So we really are able to, I think, be much more accurate and comprehensive. The human mind misses things, and
Yeah.
AI, the large language models don't miss much. And so we will ask it to prepare a series of questions based on a document in advance of a deposition of a witness, for example, or a defendant doctor. And I used to review 1,000-page medical record in front of my computer, and the record would be up on one screen, and I would have a Word document open on another screen, and view the record and type away questions and type away questions, type away questions, and it might take me days or weeks to prepare for a deposition. But now I can prepare for a deposition in a matter of days. I can spend more time reading literature and not drafting questions, because a key to a successful prosecution of a case, especially in the medical arena, is knowing as much as the doctor that you're suing or the hospital that you're suing.
Absolutely. Yeah. The speed and efficiency is phenomenal. If you were to fast forward 5 years from now, um, do you have any inkling of what you think, based on all this emerging technology and the pace at which it's moving, what would look completely different 5 years from now versus what you think will be fundamentally still the same in your field?
So I think what fundamentally will be the same is the fact that they will still need a live attorney to stand in front of a jury
Yes.
and argue the case. That will not change, at least in the next 5 years. My son and I debate whether at some point you'll hit a program on a big screen, and the case will be presented on a large screen to the jury, and it may go back and forth between the plaintiff and the defendant, but there will basically be lawyers completely cut out of the picture. Um, I've already seen and heard that hiring trends for associates are down and are going to continue to go down. So young lawyers, I mean, are going to have a harder time, I think, breaking in, because so much of the work that the associates would do are being delegated to AI by partners. And partners can find out that an associate can do a brief, and then the AI can do a brief, and they match those briefs up, and they're almost equivalent. And so, what are they paying an associate $200,000 a year in a big firm in New York if the AI can generate the brief? Um, so I see the need for a physical lawyer to still be there in 5 years. I don't even know if we can predict what the practice will be like in 5 years. I've already noticed, and what I was going to mention in response to one of your other questions is one of the fears I have is, even for my son, is that his brain will not have the training that even mine has had over all these decades of staring at medical records with my own eyes and picking up subtleties or little things that help you understand the case better. I think that AI is sort of taking away from a lot of the critical thinking and independent thinking that I think is so necessary to be a good lawyer and to be good at really in anything at your field.
That's such a great point. This is always uh, this is always, I think, part and parcel of any technological paradigm shift, right? Is that as we gain certain skills and advantages, we also lose certain things. Like, and when you said critical thinking, that is hitting the nail on the head. I mean, I've thought about this too and reflected on it for myself personally. Things that I used to have to sit down, much as you were just describing, and reason out and spend hours, days, even weeks writing and processing and synthesizing. Now I have this ability, especially because I've become somewhat expert with prompting. So I
Hmm.
get the proper parameters set use this technology and it can fast forward. I think maybe the advantage that you'll still have, your son will still have, is the fact that because there is still a human component, that at this point the technology can't replicate. It's that dealing with actual people, all the nuance of being able to interact.
Sorry, that was my dog.
No problem. All the nuance of being able um, to actually navigate the peaks and the troughs and all the changes. You took a call right before we jumped on with something going on live in a trial, in a case. So these are things that the attorney is still going to be, their human discretion is still going to be necessary. So I think that, at least for the immediate future, that will still keep the human element alive. And even if certain skills may not be quite as sharp because they don't need to be, I think, people will be embracing the technology in a way to empower them, but they still are not completely deferring to the machine. So if that makes sense. Yeah.
Yeah, it does. And just to follow up on that point, Stephen, I think that you bring up another good point, which is that I was more projecting out in terms of needing lawyers to present cases at trial, but you also need to sit face to face with your client, especially going back to that initial interview. They're not going to want to be, there's a thing that we do in this business called an intake. It's a case intake. It's either the first phone call or the first meeting that you have with the client where you are interacting with them, and you have to show empathy, and you have to be interested, and you have to look them in the eye, and you have to really engage with them in a meaningful way. That's certainly, I can't ever imagine that being replaced by AI or a computer.
Let me swing over so we can do a little bit deeper dive into your firm. What would you say? I mean, there's obviously quite a few personal injury malpractice practices out there. What would you say sets you apart from others, makes you particularly unique with your firm and your approach?
Well, I think our firm is unique in the sense that we have basically a collection of high level attorneys. So that's what I think. Each of all the attorneys in our firm is a little unique in that we kind of all have our own practices per se. It's a firm, but we each have our own particular specialties and uh, client bases. For example, there's an attorney in our firm named John August. He's been around for a long time. He is not only a wonderful man, but he is one of the quiet leaders in the field of workers' compensation in Connecticut. He is considered to be at the very top of the pyramid in that area. We have our senior partner, Hal Rosnick, has been practicing, I think he's been practicing 54 years. And he is considered an outstanding leader of the Connecticut trial bar. My son Will and I mean, again, I've been doing this medical malpractice for 43 years. I like to think that among the medical malpractice defense bar, which is where your reputation really needs to be good, is that you need to have your adversaries respect you and know that you are a real player in this particular field, because otherwise, obviously, they will not take you seriously. And so I do think that my son Will and I have developed that type of reputation, that we're sort of top end of the lawyers who handle medical malpractice cases. We do an amazing amount of preparation into each particular deposition, much less case. Like I said before, we'll spend weeks getting ready for one doctor's deposition because we know if you take a good deposition of a doctor in a strong case and you can get them to admit that perhaps their care wasn't up to standard, the case is much more likely to be resolved. So those are the things that I think set our firm apart, is that in each area, we have very top level practitioners in personal injury and medical malpractice or workers' compensation.
Team of world-class specialists. What would you say has been one of your proudest moments so far in terms of an impact or an outcome that you've gotten for a client?
So certainly, the ones that bring me the most satisfaction are where you have for example, a brain damaged baby, a child that was injured at birth. And you're never going to change the fact that that child's going to have a lifelong uh, challenge in their life. Uh, they're going to need specialized care, specialized orthopedic care, specialized neurologic care, specialized nursing care, occupational therapy, physical therapy. All of those are needs that that child will have over their entire lifetime. And if you feel that that child was, for example, this primarily arises in what we call delayed cesarean section cases. So you have a mother or a fetus who is at somewhat high risk, or even if they're not at high risk, but they start becoming post-date and they become high risk, and they're on a fetal heart monitor, which I'm sure you know what that is. And the fetal heart monitor is measuring the contractions and the fetal heart rate, and you are supposed to be carefully observing that. And if the fetal heart rate starts to decline precipitously, then you need to take the mother in for a urgent cesarean section. And there's that time, they call it decision to incision time. The time you make the decision to the time you make the incision, that's a very critical time. And if you don't recognize that the fetal tracing is not optimal and the child gets severely brain injured because it was not delivered in time, then that child's going to have a lifelong set of needs. And to hold the hospital accountable, first of all, for not doing their job, for not responding to the signs and symptoms of fetal distress, that in itself is very rewarding because I have seen uh, practices change. I took a deposition of a doctor, I would say 35 years ago, when fetal heart monitors were first coming into wide use, and he was a dinosaur. He refused to use the technology, and he insisted on using a stethoscope to listen to a fetal heartbeat for 15 seconds and extrapolate from that the health of the fetus. So when I questioned that doctor about why he didn't use a fetal monitor, he refused to concede that it was not, he should have. But ultimately, I learned after that case resolved, always use the fetal monitor after that delivery. And so there's that satisfaction of changing practices. And then when you finally are able to hand the family a large check that says this is going to provide for a handicap van, this is going to provide for a wheelchair for the rest of the child's, including into their adult life. This is going to provide for all the therapy that they need, the neurologic care. That becomes satisfying, very satisfying. As I said before, handing a check to a family who lost a child, much less satisfying. I mean, you've done your job, but it's just not that satisfying. Sorry to say.
Unfortunately. Um, in terms of growth stage, obviously you've got a very mature practice. As you said, you've got yourself and some others that have been in the game for a very long time. What stage of growth would you say the firm is in? And where are you and the partners looking to be in, say, the next 12 months or so?
I would say we probably add an associate a year, probably not much more than that. Um, so, I mean, I don't see us growing tremendously in terms of our size. We're always looking to expand our case inventory. And for example, my son and I are focused always on having only the strongest cases. We're not interested in cases that are borderline, where you're calling into question the doctor's care, that 50% of the doctors would have done it one way, 50% of the doctors would have done it another way. That's not a case. So I think our growth is going to be relatively slow over the next few years. But again, there is a number of more senior attorneys who are getting older. And as they retire or whatever, I would imagine that there's going to be a growth at that point.
Absolutely. Yeah, much more of a stability phase at this stage of the game.
I would say it's true.
I like to ask what I call the magic wand question, which is if you could hypothetically wave a magic wand and fix one constraint or challenge or limitation in the business, what do you think that would be right now?
Well, to clarify, do you mean in our firm business or in my profession per se? So for example,
I'd say specifically for the firm, but I'm
so
also
the firm, well,
maybe part two, you could weigh in just on a global professional observation.
Sure. So it's ironic that we are actually having this podcast at this time because over the past several days, my son and I, which are considered the AI gurus of the um, have been meeting with our chief technology person about what we have as what's called case management software. And I'm sure you're familiar with what that is. It's a program that basically keeps track of all of your cases, all of the documents that come in, all of the documents that go out, all of the phone calls that happen between clients and judges and lawyers. Everything is tracked electronically, digitally on a case management software. And case management software has been around a pretty long time, 20 or more years. And we have what my son and I consider to be a very archaic case management software. And so we have been looking to engage the partners, particularly the equity partners, in an understanding that we need to move on from this software. It's outdated. Just for example, if I send an email to an attorney, my paralegal has to copy that email and paste it into our current case management software for that case, which is incredibly inefficient. Um, there's case management software, which as soon as I send that email, it's automatically saved digitally in that particular client's file. So Outlook emails get saved to the digital file for that client. And so we've been really engaging the partners in the fact that there's a number of different things we need to do. We need to update the case management software. We need to get more of the attorneys using AI, such as Claude, for certain drafting tasks, to use co-counsel for legal research tasks, to use, for example, Perplexity if they need to get codes and standards, building codes, ASTM standards, to use the different platforms that we have that are out there to improve the quality of the work that you do. And then one last thing that we've recently done is I was mentioning that there are these closed systems as well. And we have recently signed a fairly big contract with a firm that provides a closed platform where we can upload unlimited amounts of data and documents to this platform. It's called Parambro. And it can do all sorts of things. It can create timelines. It can highlight key medical events. But the advantage is that it's a closed system, and you can bill that particular case cost back to the client. And we have it in our retainer agreement that we do use AI and that there are certain fees associated with that. And so that's what we're doing. We are really trying to bring our relatively old-fashioned firm really into the modern age, and it's actually happening. The senior partners are actually amazingly receptive to
Yeah.
this change.
Yeah. That is one of the challenges I've been seeing is sometimes there is that pushback where people are more, in the technology adoption curve. They're more kind of in the laggard stage. So it's really good that you're seeing that tech forward mindset from the senior
Yeah.
partners. Fantastic. This has all been excellent. Where I like to always end is we've talked about your firm, what you do. We've talked about impact of technology, where that's headed in the field, and then talked about what where you're looking to go with the firm. Where I like to always end it is on a personal note. Everyone has their kind of their primary motivation that goes or runs underneath, let's say, just wanting to be successful at what you do and make more money and grow the firm and things like that. What would you say that is for you, your personal why?
So I would say the personal why at this point is what I mentioned before. When I can actually see or feel that a medical practice or a physician has changed the way they do things, that is the biggest satisfaction. And we see it in all sorts of different areas where because of legal action, changes have been made that improve safety across the board. For example, painting yellow on parking bollards so that people don't trip over the parking bollards in a parking lot. The color contrast. Why did that come about? It came about because so many people fell over those things and were injured, and lawsuits were filed, and the insurance companies for those shopping malls said, we are not going to insure you until you paint every parking bollard yellow, and so that people do not fall over them. So that's just one example of the kinds of change that litigation or personal injury lawsuits can actually bring about. And in my particular field, the medical field, I do get the sense that when you are questioning a doctor about why they didn't do X, Y, or Z in relation to a patient, um, they will never leave that deposition room doing things the same way. And I've questioned doctors on, like a 8-year-old girl who was heavily dehydrated at a Waterbury hospital, and sadly, this child ended up dying because the doctor did not properly check on her vitals and ensure that she was simply properly hydrated. If the doctor had simply put an IV in this girl, she would have lived. And he didn't. And there was just no reason for that. And although that was one of the worst and saddest cases I've ever handled, I know that that doctor changed the way he did things. So if there's any satisfaction I can get out of this job, is trying to bring about that kind of change.
Yeah, that's fantastic, because that truly is like you're effectuating systematic change, or systemic change rather, not just a single case. That's a very meaningful impact. Great point. So, for anybody that's interested in learning more about your services, the firm, what's the best way to contact you?
So thank you, Stephen. So our firm is, as you introduced at the beginning, Miller Rosnick, Butler, August, and D'Amico, and our website is www.millerandrosnick.com. So www.millerandrosnick.com, and I can be reached at charles@millerandrosnick.com. And that's the best way to reach me. And I'd be happy to hear from anyone if they have any follow-up questions about AI or my practice. And my son, Will Price, he's will@millerandrosnick.com, and we both take calls all the time about medical malpractice and other cases.
Absolutely. Thank you so much. This is really a great conversation today. I appreciate it.
Thank you, Stephen. Pleasure to be with you.
You take care.